structure doctrine in Kenya, whilst Dr. Ojwang, Dr. Linda Musumba, and Dr. Osogo supported the notion of the applicability of the basic structure doctrine. Be that as it may, the respondents opposing the appeal expressed fear that if the legislature is left unchecked, the 2010 Constitution may be dismembered and mutilated to the extent of it being a shell of a constitution. No doubt, the respondents' deep-rooted fear is informed by the history of lack of constitutionalism in Kenya. It is for this reason that the respondents opposed to the appeal urged us to find that the basic structure doctrine is rooted in Kenya's history, text, and experience, as well as comparative constitutional theory in the form of decided cases and scholarly works. It was their argument that the courts must reconcile contradictions, draftsmanship gaps, vagueness, and phraseology in the Constitution and arrive at the conclusion that the basic structure doctrine is applicable in Kenya for the safety of the 2010 Constitution. In support of their contention, they relied on several authorities which I have set out in my judgment, and in the interest of time, I shall not go through all of them. But the ones that I brought on board into my judgment include, in the matter of the Speaker of the Senate and another, Mother Kerubo Moracha versus University of Nairobi, in the Commission for the Implementation of the Constitution versus the National Assembly, where Lenaola J, as he then was, held that where the basic structure or design and architecture of our Constitution are under threat, the court can genuinely intervene and protect the Constitution, end of quote. They also relied on the decision of Jasbir Singh Rai, and as I've said, they also relied on scholarly works, in particular the works of Professor Dietrich Conrad, writing on implied limitations. In support of the contention that the Constitution also has the unspoken language, they placed reliance on scholarly writings of Yaniv Rosnai in Unconstitutional Constitutional Amendments, the Limits of Amendment Powers, where he states, and I quote, "In order to find an amendable basic principles, one has to resort to interpretation of the Constitution as a coherent whole. It is, after all, a constitution and not just a disjointed collection of constitutional pieces which must be interpreted." According to this approach, the language of the Constitution is not merely the explicit one, but also the implicit one. The respondents opposed to the appeal argued that, notwithstanding the fact that the 2010 Constitution does not expressly bar amendments, it does so implicitly, as one has to pay attention to its overarching themes and/or the spirit of the Constitution. Heavy reliance was also placed on the Indian Supreme Court decision of Kesavananda, and in this Kesavananda decision, by a majority of 7-6, it was held that there are some provision in the Indian Constitution that form the basic structure of a constitution and hence are not even when the prescribed procedures are adhered to. On the other hand, the appellants and the respondents in support of the appeal were clear. The basic structure doctrine is not applicable in Kenya. They urged us to find that the 2010 Constitution has sufficient safeguards that militate against hyper-amendments of yesteryears. The appellants and the respondents supporting the appeal also sought to rely on case law, decided cases, the history, text, and context of the 2010 Constitution. These included in the Council of Governors versus the Attorney General, where the Supreme Court stated as follows: "Courts may not impose a meaning that the text is not reasonably capable of bearing. In other words, interpretation should not be unduly strained. It should avoid excessive peering at the language to be interpreted, end of quote. On the invocation of the spirit of the Constitution, reliance was placed on a decision of South Africa in the decision of the Premier of KwaZulu-Natal versus the President of South Africa, where the Constitutional Court held that, and I quote, "The reliance upon the spirit of the Constitution is, in my view, misconceived. There is a procedure which is prescribed for amendments to the Constitution, and this procedure has to be followed. If that is properly done, the amendment is constitutionally unassailable," end of quote. Back home, the appellants and the respondents in support of the appeal also relied on the decision of Jasbir Singh Rai. They also cited the decision of the Speaker of the Senate and another, and also the decision of the Attorney General and another versus Randu Zai Rua, wherein these courts acknowledge that the people may amend the 2010 Constitution by a referendum to alter the territory of Kenya. That is to give effect to secession. They also cited the decision of the Senate and 48 others versus the Council of County Governors and 54 others. Then there is also the decision of Titus Alila and 2 others, where Fred Ochieng judge acknowledged the fact that our Constitution does indeed make provision for the amendment of the Constitution. In my view, the above decisions underscore the fact that the 2010 Constitution is amendable, subject to the process and methodology of amendment set out in Articles 255 to 257 of the Constitution being adhered to. As regards jurisprudence from foreign lands, decisions from Malaysia, from Singapore, there were also decisions from Uganda, from Zambia and Tanzania, wherein the appellants and the respondents who are in support of the appeal relied on, and all these decisions rejected the notion of the basic structure doctrine. In particular, I wish to read some part of the decision in the matter of Paul K. Semogerere and others versus the AG. This is a decision from Uganda wherein they discounted the Kesavananda decision, and this is what they said. Those who frame the Constitution also know that new and unforeseen problems may emerge. That problems once considered important may lose their importance because priorities have changed. The solutions to problems once considered right and inevitable are shown to be wrong or to require considerable modification. That judicial interpretation may rob certain provisions of their intended effect. That public opinion may shift from one philosophy of government to another. The framers of the Constitution did not put any limitations on the amending power because the end of a Constitution is the safety, the greatness, and the well-being of the people. Changes in the Constitution serve these great ends and carry out the real purpose of the Constitution. There is also the other decision from Uganda, Male Mabarizi and others, which of course also discounted the doctrine of basic structure. So in my view, the above decisions from Malaysia, Singapore, Zambia, Uganda, and Tanzania demonstrate that the courts have rejected the doctrine of basic structure on the reasoning that a constitution, being a living document, must inevitably change as society progresses. That a living constitution must be flexible to allow for a country's growth, and the review of a constitution is essential so as to cater for new and unforeseen future problems, and hence it is inadvisable to have a constitution cast in stone. my mind, I have no illusion whatsoever that the Kenya's constitutional past was indeed a dark past. The pre-2010 constitution was misused and abused for selfish political gains. Several instances stand out. In 1974, Paul Ngei, the then minister in the late President Kenyatta's government, was found guilty of an election offense, and by operations of the law was barred from running in the ensuing by-election. To save him, His Excellency the late President Kenyatta passed into law a bill tabled in Parliament and passed into law in a single afternoon, pardoning Honorable Paul Ngei of an election offense. Then there was the 1982 constitutional amendment that dealt a death blow to multi-party democracy and turned Kenya into a de jure single-party state of the then all-powerful Kenya African National Union. The reason for the hastily carried out amendments or dismemberments of the pre-2010 constitution are not difficult to discern. The power to amend the constitution was provided in section 47 of the pre-2010 constitution, and this power was reposed solely in Parliament to the exclusion of the proverbial Wanjiku. I have cited the provisions of section 47 of the 2010 constitution. Our pre-2010 constitution, like the Indian constitution, did not bar amendability. It is against the backdrop of the Indian constitution, where there is no provision for amendment of the constitution by the constituent power, but the power to amend being reposed solely in Parliament, that the Casavananda decision was made. In his scholarly writings, Yaniv Rosnai traces the history of the basic structure doctrine and how it was developed in response to Prime Minister Indira Gandhi's attempt to amend the constitution. He states, "The Indian constitution lacks any unamendable provisions. Also, Indian jurisprudence, rooted in British tradition, initially rejected the notion of implicit unamendability. That position, however, was revised in the 1960s and 1970s following Prime Minister Indira Gandhi's far-reaching attempts to amend the constitution, leading eventually to the judicial development of the basic structure doctrine. According to this doctrine, the amendment power is not unlimited. Rather, it does not include the power to abrogate or change the identity of the constitution or its basic structure," end of quotes. Yaniv Rosnai provides a further criticism of the Casavananda case for failure to identify the unamendable clauses. He writes, "The Casavananda case did not provide a precise list of unamendable features that constituted the Constitution's basic structure, thus forming a sort of common law doctrine that develops on a case-by-case basis." And he further stated that the Casavananda judgment created a constitutional quicksand. In his written submissions, Professor Charles Manga Foreman, an amicus curiae on the basic structure doctrine, outlines the essence of this, what he refers to as the much acclaimed Indian basic structure. And he states, "The much acclaimed Indian basic structure doctrine owes its origin to the famous Supreme Court decision in Casavananda decision, although the issue had been raised in a number of earlier cases. According to this doctrine, even in the absence of explicit limitation on constitutional amendment powers, Parliament's amendment powers are not unlimited. There are, as a result, implied constitutional limitations that render an amendment unconstitutional if it infringes, negates, or substitutes the basic structure of the Constitution, regardless of whether all the formal or procedural requirements of amendment have been met." End of quote. Professor Foreman points out that when the doctrine of basic structure was developed, India was dealing with, and I quote, "India's 20th century independence constitution of the 1950s, whereas African courts are now dealing with made-in-Africa constitutions of the 21st century," end of quote. and that due to the changed circumstances, the Kesavananda decision is not relevant to our circumstances. This court has had occasion to express its reservations in adopting foreign concepts to our homegrown constitution. And I cite the case of Kenya Airports Authority versus Mitubel Welfare Society, where this court stated as follows: whereas citation and reliance on persuasive foreign jurisprudence is valuable, foreign experiences, values, and aspirations of other countries should rarely be invoked in interpreting the Kenyan Constitution. The progressive needs of the Kenyan Constitution are different from those of other countries. In my view, the position obtaining in India, insofar as it related to its constitution, was not any different from the position obtaining in Kenya before the promulgation of the 2010 Constitution on 27th of August 2010. The Indian Parliament has the exclusive power to amend the Constitution. Our Parliament has similar power to amend the Constitution prior to the 2010 Constitution. The situation obtaining in Kenya after the promulgation of the 2010 Constitution is different. There are explicit provisions on the amendments of the Constitution, as well as inbuilt mechanisms which limit Parliament in amending the Constitution. The methodology to amend the entrenched provisions is also clearly spelled out. There are also clearly spelled out entrenched provisions. Suffice to state that the Constitution itself anticipated that it can be amended, and it provided for its own amendment procedures. In the same Constitution, there are strictures as regard entrenched provisions which require a referendum and which ones do not. These are listed in Article 255(1), Subarticle A to J, and I shall not go through them. The High Court, in the impugned judgment, appreciated as much, and at part of paragraph 473 of its judgment, it stated, "To be sure, there is no clause in the Constitution that explicitly makes any article in the Constitution unamendable. However, the scheme of the Constitution, coupled with its history, structure, and nature, creates an ineluctable and unmistakable conclusion that the power to amend the Constitution is substantively limited. The structure and history of this Constitution makes it plain that it was the desire of Kenyans to barricade it against destruction by political and other elites. As has been said before, the Kenyan Constitution was one in which the Kenyans bequeathed themselves in spite of and at times against the political and other elites. Kenyans therefore were keen to ensure that their bequests to themselves would not be abrogated through either incompatible interpretation, technical subterfuge, or by the power of amendment unleashed by stealth." End of quote. In my view, whereas the High Court correctly found that there are no explicit provisions in the 2010 Constitution barring amendments, the judges erred in finding that the bar to amendment is implicit. As stated above, the pre-2010 Constitution did not have provision for the amendment of the Constitution by way of a popular initiative, and neither did Parliament recognize the notion of implicit unamendability. Indeed, the issue in Joya and others versus the Attorney General was whether the Parliament could, in the exercise of its amendment power under Section 47 of the Constitution, repeal the Constitution. I have cited a passage from that decision of Joya decision that is relevant to this judgment. It is the Joya decision that paved the way for the amendment of the pre-2010 Constitution by constituent power via a referendum. This was in recognition of the supremacy of the sovereignty of the people, who then exercised that sovereignty in the referendum that birthed the 2010 Constitution. In my view, the Joya decision was our Kesavananda moment, and to paraphrase Yaniv Rosnai, this may have been as a result of the late President Kenyatta's and the late President Moi's far-reaching attempts to amend the Constitution, and there was need to curb those excesses. As history will attest, the clamor for a new constitution was long and arduous. But that notwithstanding, when the Kenyan people finally bequeathed themselves with a new constitution, they ensured that it would be free from hyper amendments. Indeed, the 2010 constitution was informed by Kenya's dark past, and its citizenry were determined never again shall we have a constitution that can be amended at will. In the formulation of the 2010 Constitution, a conscious effort was made to ensure that we do not have hyper amendments. This conclusion is supported by findings contained in the final report of the Constitution of Kenya Review Commission, CKRC, which mirror Chapter 16 of our Constitution. I've reproduced part of the reports of CKRC that mirror Chapter 16 of our Constitution. Following the recommendations of CKRC and true to word, Chapter 16 of the 2010 Constitution is dedicated to amendment of the Constitution. In my view, the clear text and language of Chapter 16 is that there are explicit provisions in the 2010 Constitution providing for amendment, and therefore there is no reason to look outside the Constitution and import the basic structure doctrine on the basis that the Constitution has the unspoken language and or implicit provisions. And it has now been slightly more than 10 years since the Constitution was promulgated, and to the credit of the drafters of the Constitution, the 21 attempts to amend the Constitution, 19 were through a parliamentary initiative, whilst 2 were through a popular initiative, have all fallen by the wayside. These 21 attempts are tabulated in the written submissions of Mr. Ogeto, the Solicitor General appearing for the Honorable Attorney General. I have also reproduced those 21 attempts in part of this, my judgment. It is also true that the framers of our Constitution balance between flexibility and rigidity. To this end, CKRC had recommended, and I quote, that there is need to protect the Constitution against indiscriminate amendments. If the amendment procedure is too simple, it reduces public confidence in the Constitution. The converse, however, is also true. If the amendment procedure is too rigid, it may encourage revolutionary measures to bring about change instead of using the acceptable constitutional means. Thus, a balance must be struck between these two extremes. End of quotes.